Just a moment. All right, Mr. Murphy, are you there?
Yes, Your Honor. I'm sorry. I didn't know if you'd say.
Mr. Welke's with you?
Yes, can I just go grab him? He's in the lobby right now. So just give me one moment.
Okay. Well, we got a call. You had to scoot.
Just want to look this room.
Well, I finally got my lumber bit, my rider bit from repair.
Yeah.
So I want to be able to burn that.
We can hear everything you're saying, Mr. Murphy.
Yep. I'm sorry, Your Honor. I was just
All
being
right.
Mr. Lucky.
This is file number 2026-22549FH. This is in the, hold on, Mr. Reckett, I see you. I'll take you next. In the matter of the people of the state of Michigan versus David Kevin Welke. I have Matt Murphy appearing on behalf of Mr. Welke. I see Alexander Banetto's assigned, but I have Isaac Sneed appearing on behalf of the people today. Mr. Murphy, we do need a stipend order from the last pretrial from 5/27 to today. We did not receive that. Mr. Welke is present in Mr. Murphy's office. So, Mr. Murphy, how would you like to proceed today?
Your Honor, I apologize for that. We'll get that sent today. We are going to ask for just a one-day jury trial on this matter, and I have a motion to file, and then obviously we'll have that held before that trial date. But I think just a one-day jury trial should be sufficient for this trial.
All right, Ms. Adams, I'm looking for a one-day jury trial. I know we're into September, October.
All right, I am looking at.
Oh, Mr. Banetto is here on this case. Just walked in. Mr. Welke.
Judge, I'm looking at Wednesday, October 14th at 10:30.
October 14 at 10:30. Are you available, Mr. Murphy?
Yes, Your Honor, I am. Thank you.
Mr. Banetto?
Yes, I am, Your Honor.
All right, I will set this for trial on October 14 of 26. That is a one-day jury trial. I will set a final pretrial for September 23rd at 8:30 in the morning. I will ask that all jury instructions and voir dire questions be provided to the court by September 18 of 26. And I will make September 23rd of 26 the motion deadlines. All right, I have filled out a scheduling order and I will have my staff get a copy out to everybody. All right, anything else? All right.
Nothing from the
very good.
defense. Your Honor, again, I apologize for that stipend order. We'll get that done today.
All right, well, I believe you will. Thank you.
Thank you, Your Honor.
Thank you. I know that Mr. Reckett was here before everybody else. And I'm looking. There we go. Carrie Swift. Is she here?
Oh, we are trying to contact.
Let me see if she's in my waiting room. I have a bunch of people. I don't know who any of them are. All right. I have somebody on a Google Pixel 10. I've sent your request to unmute your device, please.
Okay. Yeah, David Byer.
Who? David Byer?
Yeah.
All right. I'm going to rename you. So hold on a second.
Not Google. Not Google no more.
I'm going to change it so it's your name. That's all.
Oh, okay.
That way, when I put you back in the waiting room, or well, Mr. Goldstein's here. So, I mean, just a moment.
Okay.
So Mr. Rackett, I do not see her in my waiting room. If you want me to push it to the end of call, I can do that. Okay. Do you have anything next door?
I do not.
Okay, well, you can hang out for a moment then. Mr. Goldstein,
Yes, Your Honor.
I have David Byer, if you'd like to, is he yours today?
Yes, he is.
All right, these are files number 26-22537FH, 26-22639FH. I have David Goldstein appearing on behalf of Mr. Byer. Evidently, I have Alexander Bayonetto appearing on behalf of the people. Mr. Byer has zoomed in separately from his attorney. Mr. Bayonetto is present in person. I do have a letter, Mr. Coast. So, Mr. Coast, would you like to give us an update, please?
I do, Judge. Right now, we do have a bench warrant for Mr. Byers. As part of his bond conditions, he's supposed to be doing 2 times a week drug testing.
1 time.
Prior, when he would test at the center or not show, he would immediately go over to the Tecumseh Urgent Care to test. I actually contacted Tecumseh Urgent Care, and they advised that they do not supervise their test. And so I did get notification that he was in treatment over at Maple Grove Rehabilitation back on May 12th, and he was going to stay there for about 2 weeks. He was directed to get a hold of me once he was released. He did not do that. And then I have 3 consecutive misses over at the center.
Your Honor, Mr. Byer is back at Maple Grove.
All right, Mr. Coast.
Judge, I did not have any verification of that, so.
I asked him for that, and I should be getting it today, and I'll forward it on to you.
Okay.
And Mr. Byer, you need to sign a release for Darren Coast at Maple Grove.
Okay. As soon as I see my therapist today, I'll send all that stuff to you. I got a meeting with my therapist today at some point. I'm not sure the time yet, but as soon as I get to that, I will have that all set up and send confirmation.
All right, and that's so that Mr. Coast can verify as needed. Mr. Byers, it's very important you stay there and not leave early. But if you do get released, you need to call Mr. Coast immediately and begin testing, because that's one of the conditions of you being out on bond, right?
Yes, that was. It's only once a week.
Okay, Mr. Goldstein, then I will. So, Mr. Coast, we cannot sign the bench warrant at this point, but understand, Mr. Byer, if you leave early or you don't complete the program or you don't test, we'll be back to bench warrant status again. You understand? I think it's gross.
Yes.
And
Okay.
Judge, once he gets out, I actually like to switch the testing where he actually tests with me to where we actually do swabs.
Okay, so I understand that, Mr. Byer, you're gonna be testing with Darren.
Okay.
All right, Mr. Goldstein, how else would you like to proceed today?
Your Honor, I'm going to make a suggestion. With one of the cases, he's already pled and is due for sentencing. We've been tracking it along because he then picked up the second case, which is the larceny case. We'd like to set that for a jury trial, and I suspect it won't take more than a day to a day and a half. If the court wants to go ahead and set another date for the sentencing after he finishes Maple Grove, we can go ahead and sentence him on that case, or the court can wait and sentence him after the larceny case is resolved. Either way.
Okay, so let me double check. So the larceny file is 3-9, correct?
Correct.
Yes, sir.
All right, and that's the one we're gonna set for a 1-day jury trial. Ms. Adams?
Your Honor, can we set it for 2 just to be safe?
Sure.
Yeah,
Ms.
I agree with that.
Adams?
I agree with that, Your Honor.
All right, Ms. Adams and Mr. Goldstein, obviously, we're kind of scheduling out, so he's not in custody.
Alright. We could do October 15th, following the day we set another one-day trial
October 15th.
at 9 a.m.
Um, yeah, that looks good.
And I know you're
Well, wait a
available,
minute.
Mr. Freeman.
Yes, sir.
Wait a
Wait,
minute.
oh,
Yeah, no, that's fine. October 15th should be fine.
all right, so October 15 of 26 for a 2-day jury trial. I will set a final pretrial for, we said 15 on a Thursday.
Correct.
Okay, so that would be a 9 a.m. start time. And I will set a final pretrial for September 30th, Mr. Goldstein.
That's fine, you're right, because those are usually by Zoom, so that's not a problem.
Yeah. That will be at 8:30 in the morning, and I would ask that all jury instructions and voir dire questions be provided to the court by September 25. And I will set the motion date for September 30, if there are any motions. And is there anything else we need to address?
Not on this matter, Your Honor, no.
All right, so Mr. Byers, make sure you stay in contact with Mr. Coast and you sign any releases so I can verify where you are and stay in contact with them, all right?
Yes, I will, Your Honor, and I'll have confirmation and stuff sent over as soon as I see my therapist today that I am here. So.
And Mr. Coast, at this time, I will set aside the bench warrant, all right? If I have already signed it, I don't know.
Judge, yes, you already signed it, but I'll get that recalled. Thank you.
Okay, all right,
So
thank
that's,
you.
I won't have no bench warrant now.
No.
No,
No.
you don't. All right,
Okay,
you're
all
all
right,
set.
thank you.
Mr. Byers.
Thank you.
Your Honor,
Hold
Your
on,
Honor,
everybody.
Okay, nothing
Yes,
more on
Ms.
this case.
Adams?
Sorry.
Are we still having his sentencing scheduled this Friday?
Mr. Goldstein, you just want to move that?
Let's move it to the trial date, Your Honor.
All right, we will move that sentencing date to the trial date. Okay, Mr. Goldstein, I had Mr. Rosenberg for a probation violation pretrial at 10:30, and I think that's all I had with you.
That's correct, Your Honor. That matter, obviously, as the court knows, there was supposed to be a jury trial today. But
Yes,
the people nolly-prossed. My understanding is that the probation violation was primarily the offense that he was charged with in the new file. So I didn't know how the court wanted to proceed on that.
all
Actually,
right, hold on, everybody, this is file number 2023-21322FC in the matter of the people of the state of Michigan versus Zachary Rosenberg. David Goldstein appearing on behalf of Mr. Rosenberg for a violation of probation. I do have a letter from Darren Coast stating that Mr. Rosenberg continues to do well with his 2 times a week testing, and there have been no violations. There is Ms. Holly is present. So Ms. Holly, what were you gonna add?
the violation really isn't even on the new charge. It's from the domestic violence that he pled to, and I think's already been sentenced to in district court.
That was all part and parcel of the felony case
I don't
also.
even, yeah, I don't think we even touched the new stuff yet.
Well, that case was dismissed and ended up being dismissed. So,
Domestic violence, he pled guilty to, and he got a year probation.
yeah, no, I'm talking about the felony charge that was dismissed.
Yeah, that's not part of this violation.
Yeah, I understand.
Okay.
I don't know.
So, Mr. Goldstein, Mr. Buyer, you're free to go. I'm gonna
Okay,
send you on your.
can I ask one question though? Your Honor, can I ask you one question?
No, we're not on your case anymore, so I can't. Thank you. Mr. Okay, it looks like the violation was from July of 25, assault of a Kendall Davis, took her phone and violation. If that's something he pled to a domestic violence on, and he was given probation, there are no new pending violation of probation, so, Mr. Goldstein,
I mean, we can go ahead and have a hearing, Your Honor, but and yes, he did plead. There's been no violation since that time. So I don't know how the court wants to handle it.
all right, so,
Can't we just move on with this violation?
well, it's not till 10:30. So,
Okay.
and the charges were dismissed on the felony stemming from this. I don't know, there must have
I don't
been
think-
something,
I don't know.
all right,
I don't think it had
Yeah.
anything to do with this.
okay, I don't either. This was a Mr. Moore file,
Yes,
I think.
yes, yes,
Yes,
it was.
Your Honor. It was Tom Moore.
All right, I'll talk to Tom later and I'll let you know, Mr. Goldstein. Thank
All
you.
right, we'll log back in at 10:30 then, Your Honor.
Okay, thank you.
Thank you.
All right, so, I have Walter, Mr. Montoya.
Ready, Your Honor.
Walter Nelson. Where's he at? There it is. All right, Walter, I'm assuming you're Walter Nelson.
Yes, ma'am.
All right, this is file number 2025-22209FH. The matter of the people of the state of Michigan versus Walter Douglas Nelson II. I have Brian Montoya appearing on behalf of Mr. Nelson. And I have Isaac Sneed appearing on behalf of the people. This is the date and time set for a pretrial conference. I do see that in my file. I have a plea agreement form. Mr. Montoya, is it your client's intention today to plead?
It is, Your Honor.
All right, the plea agreement form I have states that Mr. Nelson will plead guilty to count 1 and count 2. Let me find it. Count 1 is breaking and entering a building with intent that carries a maximum penalty of up to 10 years in prison. And count 2, larceny in a building which carries a maximum penalty of up to 4 years in prison and a $5,000 fine. Count 3, criminal enterprises conducting. Count 5, attempted B&E. And count 6, larceny in a building would be dismissed. Sentencing would be delayed under MCL 771.1. If restitution is paid in full during the period of delay, all charges will be dismissed at the time of sentencing. If he fails to pay the restitution but pays at least half, the total during the period of delay, count 1, 2, and 3 will be dismissed, and a misdemeanor conviction will be entered for larceny, 200 to 1,000. The parties agree to no upfront jail. If he fails to pay at least half the restitution during the period of delay, then sentencing will proceed on count 1 and 2 with the parties agreeing to no upfront jail. This is like an AG agreement. Restitution will be paid by defendant to the state of Michigan Bureau of Lottery in the amount of $15,273 and to Lightning Quick in the amount of $5,026.29. And there are no other plea agreements. Is that a correct recitation of the plea, Mr. Montoy?
It is, Your Honor.
Mr. Steen?
Yes, Your Honor.
All right, so Mr. Nelson, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor, I swear.
All right, so Mr. Nelson, you have heard the agreement that I've read onto the record. Is it your intention then to plead guilty to count 1 and 2 on this file?
Yes, Your Honor.
All right. Are you satisfied with Mr. Montoya as your attorney and the advice that he has given you?
Yes, Your Honor.
All right, and other than the Killebrew agreement that was struck between your attorney and the prosecutor, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court outside of that agreement. Is that correct, Mr. Montoy?
It is, Your Honor.
And Mr. Sneed?
Yes, Your Honor.
And Mr. Nelson, as far as you're aware?
Yes, Your Honor.
Right, sir, if a guilty plea is accepted, there will be no trial. This means that you'll be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Nelson?
Yes, I completely understand, Your Honor.
Okay. Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, Your Honor, I understand.
Okay, do you understand that if the plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea. Misconduct is defined to include, but is not limited to, absconding or failing to appear for sentencing, violating terms of conditions on bond or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions, Mr. Nelson, about the rights that I've given to you?
No, Your Honor, I have no questions.
Okay, so Mr. Nelson, how do you wish to plead to the charge that on about the time period of February 23rd of 2025 through March 24 of 2025 in Madison, I'm assuming it's Madison Township, Mr. Sneed, because it has that in the body of the count, but it just says Lenawee County above.
correct.
So, okay. In the Township of Madison in the County of Lenawee, that you did commit the offense listed in count 1, breaking and entering a building with intent. Guilty or not guilty?
Guilty, Your Honor.
And then in the same date, time, and venue, count 2, larceny in a building. Guilty or not guilty?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to these counts other than the agreement that was placed on the record?
No, Your Honor.
All right. Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during the hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, I understand, Your Honor.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Montoy?
No, Your Honor.
Mr. Sneed?
No, Your Honor.
All right. Has your attorney, other than the agreement, promised you any other term like of sentence, like fines, costs, length of probation, or anything of that nature?
No, Your Honor.
Is it your own choice to plead guilty?
Yes, Your Honor.
All right. So, Mr. Nelson, on the time period of February 23rd of 2025 through March 24 of 2025, were you an employee of, let me see, were you an employee at Lightning Quick?
No, Your Honor, I was not.
Mr. Montoy, so I'm not sure, like, do you want to voir dire?
Please, thank you, Your Honor. Mr.
There's a
Nelson,
time period.
on that time period that the judge read to you, did you and a Daniel Owen engage in conduct in order to break into a Lightning Quick store?
Yes.
Okay, and uh, you were driving the car and you were part of the entire scheme to break into that store, yes?
Yes.
Okay, and indeed, you did break into the Lightning Quick store and steal lottery tickets from inside, right?
Yes.
Okay, and then later on, those lottery tickets were redeemed at other stores for the cash value, yes?
Yes, sir.
Okay, I think that should satisfy it, Your Honor.
All right, Mr. Sneed.
Yeah, I'm satisfied with that, Your Honor. Thank you.
All right, and Mr. Montoy, the restitution amount has been agreed upon.
It has, Your Honor. We've stipulated and agreed to that.
Okay, so has the court complied with MCR 6.302 B, C, and D? Mr. Montoy
Yes, Your Honor.
and Mr. Sneed?
Yes, thank you, Your Honor.
All right, I accept the pleas. They've been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. There is a Killebrew agreement struck between the people and the defendant, and of course, the court will honor that, barring any violations of it. I am going to refer this matter to the probation department for a pre-sentence investigation. So Mr. Sneed and Mr. Montoy, so I set this out 11 months.
Yes, please, Your Honor.
All right, Ms. Adams, could I get a sentencing date 11 months out?
Yes, Judge, I was looking at June 25th of 2027.
Are you available, Mr. Montoy?
Sounds good to me.
All right. And Mr. Sneed, I presume you're available that day?
The day after my birthday, so we'll see. But yeah.
Oh, maybe. Okay, so I am going to set this for sentencing on June 25th of 2027 at 8:15 in the morning. But Mr. Coast, are you in your office? All right. So Mr. Nelson, because this is delayed, you're going to have to pay your restitution off and fines and costs as well. So, but I'm more worried about the restitution, obviously. So Mr. Coast, on these delays, he would report to you and make sure he's paying the restitution off, correct?
He would, Judge.
All right. So Mr. Nelson, I'm going to put you in a breakout room with Ms. Holly and Mr. Coast in a moment. You're going to have to meet with the probation department now. So Ms. Holly will give you direction on what you need to do there. I need you to be truthful with them about your background, also the events that occurred. They'll prepare a pre-sentence report. We will provide a copy to Mr. Montoy to review with you before sentencing. Understand failure to comply and make restitution payments could obviously result in me moving the sentencing up. So it's very important that you pay a monthly amount and get that paid off in that 11 months. And I've seen people pay off $20,000 in child support in, a year. So I know it's possible for you to do this. But during the interim, you're going to have to report to Mr. Coast. I'm going to order a $30 supervision fee through Mr. Coast during that time frame. And then he'll set up payments with you and monitor you to make sure you're making those payments.
Judge, can I get
Right.
can I get the total of the restitution and also any fines?
I'm going to get you a copy of the plea agreement, but the total for restitution is $15,273 to Lightning, or to the State of Michigan Bureau of Lottery. And then $5,026.29 to Lightning Quick.
Okay.
All right, is there anything else, Mr. Sneed or Mr. Montoy?
No,
Oh, yeah.
thank you, Your Honor.
All right, I'm gonna open up a breakout room. Mr.
Judge.
Montoy, do you want, oh, yes, oh, Mr.
I'm sorry, do we have fines and costs as well?
I'm not at this point because the restitution's so high.
Okay.
All right, so I'm gonna open up some breakout rooms. We'll address fines and costs when we come back for sentencing, because I can always give them a time period to pay that. All right, so I'm gonna open up a breakout room. Mr. Montoy, did you say you wanted to go into the breakout room?
Yes, please, Your Honor.
Okay, so Ms. Holly, Ms. Coast, Mr. Coast, and Mr. Montoy, there you go.
Thank you, Your Honor.
Thank you, and, Ms. Adams, you can copy the plea agreement to Mr. Coast as well. All right, so I have, are you Mr. Hosey?
Yes, I'm reading. He was my attorney back in 2009. I first called my first case at 8. I remember as I'm host, man.
So, Mr. Hosey, your attorney is next door. And when she gets here, I will put you guys in a breakout room. So I'm just changing your screen name so I don't keep asking you that. And then you can just kind of hang out with us for a moment until she gets here, okay?
Yes, ma'am.
All right, thank you. All right, I just admitted somebody on a Samsung device. Could you unmute your device and let me know your name?
Andrew Campo.
All right, thank you. I'm gonna change your screen name. Who's your attorney?
Miss Dumont.
All right, so let me change this. Let me, hold on a second. All right.
Oh, there we go.
Morning. Hey, this is Judge Ann Sloan. So I am ready on Marcos Ramirez. Okay. Oh, wait, maybe I'm not. I thought I had Michael Dagger Marcos here, but I don't. Scratch that. I'm ready on Gary Bowerman.
Okay, sounds good.
All right, thank you.
Bye-bye.
Okay, so Mr. Mont, let me. All right, this is file number 2026-22640 in the matter of the people of the state of Michigan versus Andrew Robert Campo. I have anybody? I have Isaac Sneed appearing on behalf of the people, and I have Katerina Dumont appearing on behalf of Mr. Campo. This is the date and time set for a pretrial. I have received a copy of a plea agreement that states, is your client going to plead today, Ms. Dumont?
Yes, Your Honor, we'd be requesting no contest based on intoxication, and I spoke with prosecution on that and they were fine with that.
And then I also received an amended felony information. The plea agreement is that, and Mr. Sneed, no objection to the no contest?
That's correct, Your Honor. Thanks.
All right, so he's going to be pleading no contest to count 2 on the amended information, which is attempted assault with intent to do great bodily harm, less than murder or by strangulation, which carries a maximum penalty of up to 5 years in prison and or a $2,500 fine. And count 1 would be dismissed along with the habitual offender. And the sentence would be, the Killebrew would be 24 months with the Michigan Department of Corrections deferred. So no upfront imprisonment, but if he violates probation, he will do 24 months in MDOC. Is that the agreement?
Yes, Your Honor, we had a Cobb's agreement where the agreement was to no upfront jail and then the 24 months would be deferred.
Okay. So, Mr. Campo, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth? Okay, so we're not picking you up. Can you state that again?
Yes.
Okay, good. Very good. All right, you can put your hand down. So, Mr. Campo, I read off the plea agreement. You've heard the statement of the prosecuting attorney and your attorney. Is it your intention today to plead no contest, count 2, attempted assault or attempted assault with intent to do great bodily harm less than murder or by strangulation?
Yes, Your Honor.
Are you satisfied with Ms. Demont as your attorney and the advice that she's given you?
Yes.
And you understand the maximum penalty for this offense could be up to 5 years in prison, but there is an agreement that if you violate, you're looking at a mandatory 24 months MDOC.
Yes.
All right, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Mr. Sneed?
Yes, Your Honor.
Ms. Demont?
Yes, Your Honor.
And Mr. Campo, is that correct as far as you're aware?
Yes.
All right, if a no contest plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have a right to have the prosecuting attorney. Which you have a right to, but Heidi was up here. Okay. Okay. You have a right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Campo?
Yes. Yes.
Okay. Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes.
Do you understand that if the plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation. You will not have a right to withdraw your plea. Misconduct is defined to include, but is not limited to, absconding or failing to appear for sentencing, violating terms of conditions on bond or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. So, Ms. Demont, did your client sign an advice of rights?
Yes.
Okay,
I can email a copy right now as well.
If you can just get that to Ms. Adams, so it can go in the file. Thank you.
Yep.
So, Mr. Nelson, or Mr. Campo, do you have any questions about the rights that I've given to you?
No.
Your attorney's advised you to be pleading no contest. So the next question, your response would either be no contest or not guilty. So, Mr. Campo, how do you plead to the charge that on or about March 20 of 2026 in the village of Clayton in the county of Lenawee, that you did commit the offense under count 2, attempted assault with intent to do great bodily harm, less than murder, or by strangulation?
No contest.
All right. Has anyone made any threats or promises to you to induce you to plead no contest to this charge?
No.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead no contest? Mr. Sneed?
No, Your Honor.
Ms. Demont?
No, Your Honor.
Other than the agreement, Mr. Campbell, that was placed on the record, has your attorney promised you any particular sentence or estimated what your sentence will be in terms of probation, fines, and costs?
No.
Is it your own choice to plead no contest?
Yes.
All right, Ms. Demont, do you wish to place a factual basis on the record?
Yes, Your Honor. I have Lenawee County Sheriff's Police Report CR number 262887-001. The current date and time is March 20th, 2026. The location is 3522 West Street in Village of Clayton, County of Lenawee, State of Michigan. Let's scroll down. The officer came in contact with Tanya Matthews at Hickman Hospital. She indicated that her and Andrew are in a dating relationship. They reside together in Clayton. She indicated an argument ensued, and Andrew put her in a chokehold. She stated he put his arm around her neck and applied pressure. She said she then broke free from the chokehold, and that she also believed her eye was injured at some point during the struggle, but was unsure when. So I indicated they lived together and were in a dating relationship. So I think that's all the elements.
Mr. Steen?
People are satisfied.
All right, based on,
It's not till 10:30 that she. Yeah, they just needed, she just needed to sign the motion.
all right, based on the facts placed on the record and from the information contained in the police report, the court finds beyond a reasonable doubt that on or about March 20th, 2026 in the Village of Clayton in the County of Lenawee, that the defendant did commit the offense listed under count 2, attempted assault with intent to do great bodily harm less than murder or by strangulation, and that during an altercation, he did place the victim in a chokehold with his arm. And then in that altercation, her eye, she did sustain some injuries to her eye, to her face evidently. So I find that the defendant did commit the offense listed in count 2, and therefore the court accepts the no contest plea. Has court complied with MCR 6.302 B, C, and D? Mr. Sneed?
Yes, thank you.
Ms. Demond?
Yes, Your Honor.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. Other than the Cobb's agreement that was placed on the record, this court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. Ms. DeMont, are you available for sentencing on August 28th at 8:15?
Yes, Your Honor.
All right, Mr. Campo, you do have the right to be present in person for sentencing. Obviously, there is a deferral in this case, so you're not looking at upfront jail on that day, barring any violation of bond conditions. So do you wish to appear in person or via Zoom?
Probably in person.
All right, so I will set that in person. All right, so Mr. Campo, in a moment, I'm going to place you in a breakout room with Ms. Holly. Ms. DeMont, do you want to be a part of that?
Yes, Your Honor.
Yes, okay. Ms. Holly is going to give you some instructions. You're going to have to come in and meet with the probation department. When you meet with them, be truthful about your background. Obviously, you have entered a plea of no contest, so you are not required to make a statement about the events that occurred. And we will see you back here for sentencing on August 28th at 8:15 in the morning. I'm going to open that breakout room.
Okay.
Then you're free to go, Mr. Campo. Hey, this is Judge Ann Sloan. Well, I lost Mr. Degemargo's again, but I am ready on Tony Rowe and Chad Marvin.
Tony Rowe and Chad Marvin.
I think I have Gary Barham in my waiting room, so.
Yes, you do.
Okay, and then after that, who has Jake Klein? Rhonda Underwood, I think. All right, so I think I'm good. Thank you.
Okay, sounds good.
Bye.
Bye.
Is Kevin Barnett here? Okay, you've been here all morning. I was like, maybe you're here. Why don't you come up to the podium? Thought that was you, but All right, this is file number 25-22302FH in the matter of the people of the state of Michigan versus Kevin Lee Barnett. Mr. Barnett, we are here today on a request and summons for probation violation. I do have Joanne Holly present. The allegation, Mr. Barnett, is that you committed a technical violation and violated the terms of your probation, that you provided probation in this court with false documentation of a completed treatment program with John Bailey. Per John Bailey, you have not completed treatment, completing only 12 of 26 sessions, last attending June 8 of 26, leaving early for bad internet connection. So, Mr. Barnett, you're currently on probation for an R&O, which carries a maximum penalty of up to 2 years in prison, and careless driving, that's a 93-day still. So, do you understand if you plead guilty, if you're found guilty, you could be facing a jail or prison term?
Yes, Your Honor.
All right, so Mr. Barnett, you have a right to have an attorney represent you at this and all subsequent hearings. If you can't afford to hire one, we will appoint you one at public expense. Was Mr. Amadeo a hire, or was he appointed as a conflict attorney?
He was a hire, Your Honor.
Okay, so are you able to retain counsel at this point?
So there was a conflict of interest with the other.
No, I was asking if he was a conflict
Oh.
attorney or a retained counsel. So today, do you wish to hire an attorney, and I'll give you another date, or do you wish for court appointed?
Court appointed, please.
Okay, are you currently employed?
I am.
Where do you work at?
Michigan Power.
Okay, and how much do you make per hour?
15 minutes.
Okay, and do you have any children?
I do.
How many people live in your home?
I pay child support for my 2 boys,
How much you pay a month?
$160.
Okay. All right, I think you do qualify for court appointed counsel. So, Miss Underwood is our court appointed attorney for these violations of probation. So if you want to stay in the courtroom, she has some other cases, but we can see you today.
Okay.
Okay, thank you. All right, so. I have Ryan Fry is here. I called for his people, waiting on Joanne. Mr. Murphy was here before you. Have you already gone to Judge Olsavers or no?
Yes.
You have? Okay. Mr. Murphy,
I have Mr. Bauer. Do you want me to get Mr. Bowers?
Mr. Bowers? Do I have
He's
Mr.
in my-
Bowers?
He's in my office, Your Honor. Somewhere
Okay.
waiting.
Let me go get him. Trying to figure out my routine, because usually, like, I had 2 attorneys came here first, 2 went there. You usually would have gone there, so I was just making sure you got them down there. All right, do you need a breakout room with Mr. Bowerman or no? No, all right, Mr. Bowerman, just a minute, all right?
Yes, Your Honor.
All right, this is file number 2025-22231FH. This is in the matter of people of the state of Michigan versus Gregory Allen Bowers. This is the time set for pretrial. I have Matt Murphy appearing on behalf of Mr. Bowers. Mr. Bowers is present in his office. I have Alexander Bayonetto appearing on behalf of the people. I have received an advice of rights signed by Greg Bowers and a plea agreement form that states that Mr. Bowers will plead guilty to possession of cocaine with a kilobrew to no upfront jail. So was there an amended information?
Your Honor, I believe there was one filed last year. The one I have in my file is dated July of 2025. Looking at the ROA, it looks like the second count of possession of cocaine is on there, so I believe it should be.
So hold on, let me see if I can find it. So many advice or rights for me. Here we go. Got an updated information. So it will be pleading to an added count to possession of cocaine, which carries a maximum penalty of up to 4 years in prison and or a $25,000 fine. His habitual offender third offense notice will be dismissed, and there's kilobrew to no upfront jail. So, is that a correct recitation of the plea?
It is, Your Honor.
And Mr. Murphy?
Yes, Your Honor.
All right, Mr. Bowers, you want to raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, and Mr. Bowers, your audio is good. Just make sure you speak up. All right,
Yes,
so
Your
Mr.
Honor.
Bowers, is your intention then today to plead guilty to the added count to possession of cocaine less than 25 grams?
Yes, Your Honor.
And you understand the maximum penalty for that could be up to 4 years in prison.
Yes, Your Honor.
Now, there is a Killebrew agreement to no upfront jail and I'm assuming probation. Do you understand that?
Yes,
Mr.
Your Honor.
Bowers? All right, neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed any other possible sentence with the court. Mr. Murphy, is that correct?
Yes, Your Honor.
And Mr. Bowers?
Yes, Your Honor.
And Mr. Bandetto?
Correct, Your Honor.
All right, if a guilty plea is accepted, there will be no trial. And we are scheduled for trial on August 4. This means that you'll be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and the court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Bowers?
Yes, Your Honor.
All right. Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, Your Honor.
Do you understand that any appeal from the conviction, or I'm sorry, do you understand that if the plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea. Misconduct is defined to include, but is not limited to, absconding or failing to appear for sentencing, violating terms of conditions on bond, or the terms of any sentencing or plea agreement, otherwise failing to comply with an order of the court pending sentence. So in this case, there's a Killebrew to no upfront jail. But Mr. Bowers, if you don't appear for sentencing, you don't appear, like I said, if you don't appear for sentencing, if you catch a new case, or you violate your bond conditions in some way, I will be able to give you jail and you won't be able to withdraw your plea. Do you understand that?
Yes, Your Honor.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions, Mr. Bowers, about the rights that I've given to you?
No, Your Honor.
All right, so Mr. Bowers, how do you plead to the charge that on or about December 3rd of 2022 in the city of Adrian in the county of Lenawee that you did commit the offense listed in count 2, controlled substance possession of cocaine less than 25 grams? Guilty or not guilty?
Guilty, Your Honor.
Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, Your Honor.
You understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea. Do you understand that?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Murphy?
No, Your Honor.
Mr. Bandetto?
No, Your Honor.
Has your attorney, Mr. Bowers, promised you any particular sentence or estimated what your sentence will be other than the agreement?
No, Your Honor.
Is it your own choice to plead guilty?
Yes, ma'am.
So, Mr. Bowers, on December 3rd of 2022 in the city of Adrian in the county of Lenawee,
Yes, ma'am.
and did you have in your possession cocaine?
Yes, ma'am.
and you know it was cocaine?
Yes, ma'am.
And would you agree it was less than 25 grams?
Yes, ma'am.
And you had no legal right to possess it?
Yes, ma'am.
Has the court complied with MCR 6.302 B, C, and D? Mr. Murphy?
It has, Your Honor. Thank you.
Mr. Banetto? Right. All right, so I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. There is a Killebrew agreement in this case, and I will honor that, barring any violation of bond conditions. I'm going to refer this matter to the probation department for a pre-sentence investigation. Mr. Murphy, are you available for sentencing on August 28th?
Yes, Your Honor.
All right, because there is a Killebrew agreement to no upfront jail. Mr. Bowers, you can appear in person, you can appear via Zoom, you can appear via Zoom with Mr. Murphy. How would you like to appear?
I like coming down here to his office.
All right, so you can appear via Zoom from Mr. Murphy's office, or you can come in person, okay?
Okay, thank you.
All right, so what I'm going to do now is put you in a breakout room with Miss Holly. Where'd Miss Holly go? There it is, with Miss Holly, and Miss Holly is going to give you some instruction about when you need to come speak with the probation department. When you do speak with them, be truthful with them about your background, be truthful about the events that occurred, and then we will see you back on August 28, 8:15. Someone will prepare a pre-sentence report, and we will get a copy to Mr. Murphy to review with you before the day of sentencing. So there you go. Go join that breakout room. Thank you.
Thank you.
All right, so Bowerman, do you want to? Miss Underwood, I will also advise you, I do have a pickup this morning or a violation of probation for you on Mr. Barnett, but he's here and I can modify a breakout room for you. All right. Mr. Bowerman. All right, this is file number 2025-22242FH, 2025-22243FH, 2025-22277FH, 2025-22469FH, 2025-22479FH. This is in the matter of the people of the state of Michigan versus Gary Scott Bowerman. Mr. Bowerman is in custody of Lenawee County Jail. I have Christine Beecher appearing on behalf of Mr. Bowerman, and I have Alexander Bayanetto. Are you on all the files?
Your Honor, I'm on two of them. Ms. McClure is on the rest.
All right. Well, I have Alexander Bayanetto appearing on behalf of the people today, although he is not on all the files. So, Ms. Beecher, how would you like to proceed today?
Thank you, Your Honor. Your Honor, I have referred Mr. Bowerman to recovery court. We haven't yet gotten an answer. So at this time, I would ask for an adjournment. I believe prosecution will stipulate to an adjournment.
Okay.
If he was referred and we have the paperwork, he'll probably be screened today.
Okay.
Okay. All right. So, how about August 12 at 8:30 in the morning? And Ms. Beecher, do you mind doing all the step-in orders to adjourn?
Of course. Thank you, Your Honor.
All right. And Mr. Bayanetto, can she sign your name with permission?
She can, and she can sign for Ms. McClure as well.
All right. So we will, Mr. Bowerman, you'll probably, if the paperwork's been received, be screened tomorrow. And then we'll get an answer to Ms. Beecher. And we will see you back for pretrial on August 12 at 8:30 in the morning. Thank you, Mr. Bowerman.
Thank
Thank you. Have a good day, Jack.
You too. All right. And then the discount. Mr. Murphy. Murphy. Hey, this is Judge Anselone. So I'm now ready for Johnny Bridges, David Signs, and Rhonda, do you have Jake Klein?
I do, I believe.
And Jake Klein.
Same Bridget Klein?
Yeah, I'm ready for everybody.
Good.
Okay, thank you. Bye. All right, so let me find my AG file. So when we get Mr. Bridges, I do have Miss Messer here, so. All right, so Mr. Fry, are you ready?
Yeah, if I could talk to my transfer in the breakout room here.
Mr. Marvin or Mr. Rowe?
Both, either one first, it doesn't matter.
Okay, so I'm gonna go with Rowe. That is Tony Rowe, right?
Ma'am.
Okay. All right, this is file number 2026-22624FH in the matter of the people of the state of Michigan versus Tony Michael Rowe. Is this your file, Mr. Bana?
It is your.
All right, I have Brian Fry appearing on behalf of Mr. Rowe, and I have Alexander Bayonetto appearing on behalf of the people. Breakout room. Oh, my screen just died. All right. All right, Mr. Rowe and Mr. Fry, you're gonna get an invitation to join that breakout room. Go ahead. All right, Miss Underwood. All right, Mr. Powell, do you want to start your video and audio, please? All right, Mr. Powell, can you hear me?
Yeah.
Yep, okay, great. This is file number 2026-22606FH in the matter of the people of the state of Michigan versus Gregory Nelson Powell. I have Rhonda Underwood appearing on behalf of Mr. Powell, and I have Alexander Bayonetto appearing on behalf of the people. This is date time set for pre-trial. Miss Underwood, how would you like to proceed today?
Thank you, Your Honor. Mr. Bayonetto and I are talking about how we want to do a resolution in this matter, and I think we need just a little more time. So if the court could set it over just a couple weeks.
Okay, my next available is August 5 at 8:30 in the morning. So I will adjourn this to August 5 at 8:30 in the morning. Mr. Powell and Miss Underwood, you will do the step in order to adjourn.
I would be happy to do that with Mr. Bayonetto's permission, Your Honor.
You can, thank you.
All right, Mr. Powell, we'll see you back on August 5 at 8:30 in the morning. Thank you. You're all set. So, Mr. Barnett, what's your name?
Caleb Anderson.
Oh, Miss Underwood, I have Caleb Anderson.
I'm not sure if I have Mr. Anderson, Your Honor.
I show, hold on. Okay, I showed that we arranged him. We had a settlement conference. I don't know. Oh, I don't know why it says prosecutor settlement conference, but you were appointed back on June 4, so it's an older one. Do you want to come up to the podium? Yeah. So it is an older one, Miss Underwood. They
Hang
haven't
on,
been
Your
here.
Honor. Let me,
Miss Holly, is he paid off the restitution?
Yes. He's paid. And the retail fraud. Hold on, I gotta look at this one.
Call the files, Miss B.
Yeah.
Hold
he
on, let
put-
me call the files real quick.
Okay, I'm
I didn't
sorry.
call the files yet. Hold on. So this is file number 2022-21106 FH, 2022-21127 FH, 23-21247 FH. I'm sorry. So these are violation of probation pretrials. So Miss Holly, proceed.
Okay, so I believe the retail frauds were taken care of, maybe even dismissed. He still has a meth issue that we probably should deal with. He just completed tether for his parole. So they already sanctioned him for this whole thing by putting him on tether. So that's done. He still has a meth issue that they're working on. So that's the only thing we're addressing right now.
Okay, but he's paid out the restitution.
Yes, his fines and costs were paid. Yes, and I think I just extended them for that reason, or no, to wrap this up.
The what?
I extended him to wrap up these charges. He has paid off.
Okay, so it looks like he's complied with the issues for the violation of probation is what you're telling me.
Yeah. Yes.
So Miss Holly, can I dismiss the violation of probation?
You can do that. They're handling him in our Wayne County for his parole, so yes, that would be no problem with me.
All right, so Miss Underwood, good job twisting my arm. I'm gonna dismiss these violation of probations. So he's still on probation with you, but it's transferred to Wayne County is what you're saying, Miss Holly?
Yes.
Your Honor, Miss Holly and I did discuss this, I believe, a couple days ago.
All right, and what city do you live in?
I'm out of Belleville right now.
Okay, all right, so do you understand you're still on probation and you're on parole, so good luck in your recovery.
When I'm done with the parole, because I get off the parole at the end of August, August 27th, do I return here to see Miss Holly? Or
We extended you to, what's your out date now? May of 27?
August 27th is what time I get off of parole.
August of
Oh, but
27th.
what about
This year,
probation?
like next month.
He's off probation next month, or parole next month, Miss Holly.
Right, but I think we extended his probation. So when you get done with parole, come see me on the next Tuesday that you're done with them.
Okay.
And we'll look at this case, okay?
Okay, thank you.
All right.
Good luck to you. Thank you. Okay, Tony Rowe. All right, this is file number 26-22624 FH. In the matter of the people of the state of Michigan versus Tony Rowe. Mr. Fry, you did have a breakout room. Mr. Fry, you do owe me a stipend order from June 17 to today for pretrial purposes. So how are we proceeding today, Mr. Fry?
Yes, Your Honor. So I will get that in Your Honor's report. But I did speak with Mr. Rowe. Apparently, he has a new case that I didn't know about, and the public defender's office is representing him on that. It's set for a hearing in front of Your Honor on August 5th. So we would ask for this to be set over to the same time on August 5th. And I can talk to the public defender and the prosecutor about that in the meantime. My understanding is my client is in jail on that new case. He has a $600 bond that he is not going to post because he has some drug issues and feels like it's best for him to be in jail right now. He has a PR bond on this case. We'd ask that the court to put a bond on this case so he gets credit for the time. He is talking he is talking to Miss Fitzgerald in the jail about getting into a rehab program. So we would ask for permission for him to be able to go into a rehab if a spot opens. And I'm also planning to submit a screening for recovery court for Mr. Rowe.
All right, so I'm gonna put $100 cash bond on this file. Obviously, if there is approval to get into a program, I will just contact my office, Mr. Fry.
Okay.
And if you're putting him in for a screening for recovery court, I'm sure I'll see that at some point. All right, so I'm gonna set this for another pretrial on August 5 at 8:15. So I think Mr. Fry could probably do a double step in order. And
Okay.
Mr. Abanetto, can you sign your name with permission?
You may, thank you.
All right, Mr. Rowe, you're all set. Thank you.
Thank you. Have a nice day.
You too. All right, we grab Mr. Marvin's file. I know you said you wanted to talk to him. Oh, just got spinner. All right, this is file number 2025-22239FH, 2025-22259FH, 2025-22272FH, 2026-22667FH, 26-22668FH, and 26-22669FH. I have Brian Fry appearing on behalf of Mr. Marvin, and I have Dave McCready appearing on behalf of the people. This is the time set for a pretrial conference. Mr. Fry, how do you wish to proceed?
Your Honor, if I could have a breakout room with Mr. Marvin?
Yep. So, Mr. Marvin, I am going to open up a breakout room, and you are in jail Zoom 5. And when you get the invitation, just go join it. There you go. All right, Miss Underwood. All right, I have another gentleman in orange in jail Zoom 1. What is your name?
My name is David Tyne.
All right. So this is file number 2024-22047FH. So Miss Underwood, you're on this file, or Miss Zilke?
I thought it was Ms. Zilke.
All right, Mr. Sines, bear with me for a minute because I realize I have MDOC here, and I didn't forget about you, Mr. Hosey, but I'm going to go to Mr. Hosey so we don't lose him. All right, this is file number 2026-22657FH in the matter of the people of the state of Michigan versus Ronald Vincent Hosey. I have Rhonda Underwood appearing on behalf of Mr. Hosey, and I have Alexander Bayanetto appearing on behalf of the people. Miss Underwood, how do you wish to proceed today? Do you need to talk to
Mr. Hosey in a breakout, Your Honor?
Yep. So Mr. Hosey, I'm going to put you in a breakout room with Miss Underwood. And I think you're on a polycom, so you'll go automatically. And then when Miss Underwood comes back, I will bring you back in, okay?
Yes, Your Honor.
All right, there you go. Yep, he went automatically. Okay. What's your last name again?
Lamley, Noah. Judge, seconds, for Mr. Rocket, I had to approach about the Carrie Swift case in case she shows up.
James. Yeah. Travis, no, wait, this one too. He does.
They don't work for me like they do.
They do, I just don't think they do.
Well, there's that.
I don't think she's gonna show up. What I do, she doesn't show up. Have to be, yeah. So do you want me to call the case? I don't think she's gonna show up. And then obviously you find her. Okay. Do you want him to handle the pre-trial?
Sure.
Another one. Okay. All right, we are gonna skip over to file number 2025-22497FH in the matter of the people of the state of Michigan versus Carrie Ann Swift. I have Alexander Bayonetto appearing on behalf of the people, and then, and I have Dylan Rockett and
Edward Maxim Zach, yeah, people.
say it louder in the microphone.
Oh, Edward Maxim Zach.
All right, appearing on behalf of Ms. Swift, who unfortunately has not joined us this morning. We are scheduled for trial on July 29. It's my understanding at this point she has not appeared.
Correct.
So I will issue a bench warrant for her arrest, and I will set bond in the amount of 25,000 cash. If she reaches out to you and you have contact with her, let me know, and I will not sign the bench warrant. And then it's my understanding we're going to be adjourning the trial too.
Yes.
So, maybe she'll show up for trial on the 29th, but we'll make the, do you want me to take the trial off the docket, or do you want me to leave it on as a pre-trial?
Maybe leave it on as a pre-trial.
All right, so I will set the July 29th trial as a pre-trial. All right, anything else?
No, Your Honor.
All right, so July 29, 8:30 pre-trial. All right, very good, thank you.
Thank you, Your Honor.
Is Carly Zilke here today?
She is, I checked, and he's for a Bob with Rhonda. So it's not.
Got it, thank you. All right, so we are just waiting for Miss Underwood. I'm gonna take some of these files back to Miss Adams. So many.
Please rise, the court's now in session. May you sit.
All right, Miss Underwood, let me bring MDOC back. Oh, wait, I gotta just bring him back.
Your Honor,
Hold on. All right, we are back on the record in file number 26-22657FH. So, Ms. Underwood, how do you wish to proceed?
Your Honor, we're going to be, I believe, taking a plea in this matter. That's why I was going to suggest maybe I should get to Mr. Bridges so we can.
I can't hear.
Get the AG out but Mr. Bridges is saying he can't hear.
Hey, this is Judge Anselm. Mr. Bridges in jail Zoom 4 is indicating he can't hear us.
Okay.
All right, thank you.
In a different booth.
Okay, bye.
Bye.
All right. Are we on Bridges? Yeah. But no, we're not on Bridges. Okay, thank you. All right, so we're back with Mr. Hosey while we're remedying that. Miss Underwood, how do you wish to proceed with Mr. Hosey?
Your Honor, the offer to Mr. Hosey is as charged, no supplements, and we would be requesting a COBS to the low end of the guidelines. Your Honor.
All right, is that a correct recitation of the plea, Mr. Bandetto?
Yes, Your Honor.
Okay, so, Mr. Hosey, do you want to raise your right hand for me?
Sorry,
Okay, it's okay. Do you solemnly, you're fine, I can see. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes,
Okay, so can you state your full name for the record?
Ronald Vincent Hosey.
All right, thank you. Now, Mr. Hosey, I'm gonna apologize in advance. They have you way across the room from the Polycom. So I'm gonna ask that you kind of speak loud enough that you're almost yelling at me, okay?
Yes, ma'am.
All right, perfect. Now, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead as charged to count 1, assault of a prison employee, which carries a maximum penalty of up to 5 years in prison and or a $2,500 fine with a COBS agreement that I would sentence you to the low end of the guidelines? So is it your intention to plead guilty to that?
Yes, Your Honor.
All right. Are you satisfied with Ms. Underwood as your attorney and the advice that she has given you?
Yes, Your Honor.
All right. And any habitual offender would be dismissed as well, Mr. Bandetto and Ms. Underwood?
That's correct, Your Honor.
Okay. So Mr. Hosey, other than the agreement that was placed on the record, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. Underwood?
It's correct.
Mr. Bandetto?
Correct, Your Honor.
And Mr. Hosey?
Yes, Your Honor.
Good. If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you do have the right to testify at your trial if you want to testify. Mr. Hosey, do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Hosey?
Yes, Your Honor.
Good. Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, Your Honor.
Do you understand that if your plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, The court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea. Misconduct is defined to include, but is not limited to, absconding or failing to appear for sentencing, violating terms of conditions on bond, or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court, pending sentence. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Mr. Hosey, do you have any questions about the rights that I've given to you?
No, Your Honor.
All right, Mr. Hosey, how do you wish to plead to the charge that on or about April 1 of 2026 in the city of Adrian in the county of Lenawee, that you did commit the offense listed under count 1, assault of a prison employee? Guilty or not guilty?
Guilty.
Has anyone made any threats or promises to you to get you to plead guilty to this charge other than the agreement on the record?
No, Your Honor.
All right, do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, Your Honor.
Is prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Ms. Underwood?
No, Your Honor.
Mr. Banetto?
No, Your Honor.
All right, so Mr. Hosey, on April 1 of 2026, were you an inmate at the Gus Harrison facility?
You was talking, I'm sorry, Mom. You thought, were you talking to me? Sorry.
Yeah, Mr. Hosey, on April 1 of 2026, in April of this year, were you incarcerated at Gus Harrison?
Yes, Your Honor.
Okay, would you agree that's in the city of Adrian in the county of Lenawee?
Yes, Your Honor.
All right, and at that time you were lawfully in prison there, is that correct?
Correct, Your Honor.
All right, and then at some point you came in contact with a correction officer, Panagua, I believe, Panagua, who was employed there as a correction officer, is that correct?
Correct, Your Honor.
And Ms. Underwood, can you tell me what happened?
Mr. Hosey, did you hit Officer Panagua?
Yes, I hit her. And
you hit her with your fist?
My fist in the face. I hit her in the face somewhere. I don't know where. I just did it real quick.
Okay. Thank you.
Sure.
Mr. Banetto?
I'm satisfied, Your Honor.
All right, has the court complied with MCR 6.302 B, C, and D? Ms. Underwood?
It has.
Mr. Banetto?
It has, Your Honor.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them, other than the Cobb's agreement to sentencing at the low end of the guidelines. I am going to refer this matter to the probation department for a pre-sentence investigation. I'm going to set sentencing for August 28 at 8:15 in the morning. Mr. Hosey, where are you currently incarcerated?
In Palm Correctional Facility, Your Honor.
Okay, so Mr. Hosey, you do have the right to be present in person for sentencing. That is your choice. So you have a choice. Do you want to appear in person or via Zoom?
Zoom.
Okay, so we will set that via Zoom. So Miss Holly, do you need a breakout room with them at this point or no?
No, I don't think so.
Miss Adams?
I apologize. We need him brought in person for fingerprints.
Oh, so Miss Underwood, we don't have fingerprints. So Mr. Hosey, We don't
Oh,
have
no.
fingerprints on you. Now, we're gonna set sentencing in person for that purpose, but a lot of times MDOC will make sure those get done before, so that way they don't have to bring you. So it can be in person for fingerprints. All right, Ms. Holly, you don't need a breakout room, right?
Correct.
Okay.
I don't think so.
All right, so somebody is gonna reach out to you, Mr. Hosey, for a pre-sentence report. Be truthful with them about your background. Be truthful about the events that occurred. They'll prepare a pre-sentence report. We will get a copy to Miss Underwood. Miss Underwood's very good about getting into phone calls or meeting with clients in MDOC. If for some reason she can't, I will give her a chance to speak with you that morning, okay?
Yes. Question, Your Honor, you said August 28th?
Yes, sir.
Okay, that's the sentence date?
It's what?
The sentence date is August 28th, right?
Yes, sir.
Thank you, Your Honor.
All right, thank you. Have a good
Your Honor,
day.
Okay.
Do you need
All right,
us to
have a
do
good one,
the
Your Honor.
in-person writ for that one?
Yes.
Okay, I just want to make sure.
All right,
Thank
bye,
you.
Mr. Hosey.
Okay, see y'all.
Hold on one second. I don't see that I have Mr. Bridges back. But there he is. Mr. Bridges, can you hear me now?
Yes.
All right, Mr. Marvin, I have not forgot you, but hold on a minute. All right, this is file number 2026-22611FH in the matter of the people of the state of Michigan versus Johnny Ray Hoyle Bridges. I have Rhonda Underwood appearing on behalf of Mr. Bridges. I have Ashley Messer appearing on behalf of the AG's office. This is the date and time set for pretrial in this matter. Ms. Underwood, I believe you're going to try to get some information from the last time. And Mr. Rahol, I did in fact go back and view that video, and you did in fact tell me that I wasn't going to be able to get that money to apply for anymore. But Ms. Underwood, that being said, were you able to get any information, Ms. Underwood?
Your Honor, I talked to Ms. Kneisel yesterday, and she believes she saw a deposit, but she can't find it anywhere. I then put in a call to Mr. Bridges' workman's comp attorney and left a message. I have not heard back from him today yet. So I don't have as much information as I would like to have for the court or Mr. Bridges.
All right, are you able to see anything, Ms. Messer?
Yes, Your Honor, I did check the MICE system. It does not appear that there has been a payment made and applied since 2023. There's not even anything that's applied in the history that is just pending to be applied to the arrearage. There's nothing at all, Your Honor, received.
So, Mr. Bridges, I know that if it was made within 24 to 72 hours, sometimes it doesn't show up. So that might be what we're dealing with.
I was told sometime, not to interrupt, I apologize. I was told sometime this week that it should appear. The lawyer did send it directly to you guys, the 3,100 and something, and my mother has the rest in cash.
Okay.
So I hope in a couple days, in a couple days that you should receive the lump sum, and we'll pay the difference in cash.
Okay. Is that Ms. Underwood for the bond?
Yeah.
Okay. So your mom should probably come in and pay that so that.
I told her to wait. Sorry again. I told her to wait until you guys got the first payment. But I can have her come up.
Well, yeah, because I mean, as soon as that 5,000 is met, you'll get released. Okay, Ms. Underwood, obviously we're waiting on all that. So how do you wish to proceed otherwise?
I think, could we proceed with just like a week or two adjournment, Your Honor, to,
My next available pretrial is August 5 at 8:30 in the morning.
Your Honor, I will take that with the proviso that I'm well aware of the court's number if I need to get in sooner.
Yes, and Mr. Bridges, obviously, if that gets paid and you get released, reach out to Miss Underwood right away, all right? And then we'll see you back August 5 at 8:30 in the morning. Anything else, Miss Messer?
Nothing. Thank you, Your Honor.
All
No,
right,
thank you,
and
Your
Miss
Honor.
Underwood, you can do the stipend order. Miss Messer, can
I
she
would be
sign your
happy
name?
to do that.
Absolutely, Your Honor. Thank you.
All right, thank you, Mr. Bridges.
Thanks.
Okay, so Miss Underwood, I'm gonna go to Mr. Fry next, but I do have two of your clients here today. I have a new appointment, which is Mr. Barnett, and then I have Mr. Lamley in the courtroom. Do you need a breakout room with them?
Yes.
Okay, who would you like to see first?
I believe, let me see, Mr. Lamley.
Mr. Lamley, my bailiff's gonna take, now listen to me, Mr. Lamley, listen. My bailiff's gonna take you out and hook you up to the Polycom. I'm gonna put you in a breakout room with your attorney. When you're done talking to her, leave that on. Don't turn it off. And you come back in the courtroom because then I'm gonna send Mr. Barnett out to talk to her as well, all right? Okay, and that was, and that was file number 24-22063FH, the matter of the people of the state of Michigan versus Noah Lamley. Obviously not. And Rhonda Underwood is appearing on behalf of Mr. Lamley. That's a lot. All right, so let's go back to Mr. Marvin. Well, I'm gonna open up that breakout room.
Okay, same right here so they can see.
All right, I'm sending the invitation to join. There we go. Click on join the breakout room. All right, so we are back on the record. File number 25-22239FH, 25-22259FH, 25-22272FH, 26-22667FH, 26-22668FH, and 26-22669FH. In the matter of the people of the state of Michigan versus Chad Thomas Marvin. So, Mr. Fry, you had a breakout room with Mr. Marvin. How do you wish to proceed today?
Your Honor, we would be asking for a short adjournment in this case to allow some time to talk to the prosecutor, about the case, and figure out if we're gonna have a resolution or if a trial needs to be scheduled.
So my next available is August 12th at 8:30 in the morning. Now, Mr. Marvin, hold on. If there's a resolution, Mr. Fry will call my office and I'll get you in right away. All right. So, but that's my next available. So August 12th at 8:30, and Mr. Fry, I will let you do the stipend order to adjourn all those files except for the violation of probation ones. We'll do the notice on that. And then, as I said, if there's a resolution, Mr. Fry, let us know. We'll get them in right away.
Your Honor, I'm actually not available on that day.
That's fine. Then August 19th.
Oh, God, dude. Come on.
Mr. Marvin, as I said, if it's resolved, I'll get you in right away. All right. Thank you.
Is Mr. McCready the prosecutor?
Yes.
Thank you.
I don't know, actually, I was the boss. Mr. McCready, are you on the new files?
Either I'm on the file or I'll stand in for whoever's on those files.
Okay. All right, we're all set. Thank you.
And you can sign my name to the stipend order, Brian.
Thank you.
Yep.
And then we'll do the notice on the Bobs. Okay. So then I have, all right, Mr. Fry. Oh, not Michael Deggermer goes in there quietly. Hey, this is Judge Anslona. I am ready on Marcos Ramirez.
Sounds good.
Thank you. Bye. All right, Ms. Underwood, we are going on the record with Mr. Lamley. So this is file number 2024-22063FH in the matter of the people of the state of Michigan versus Noah Lamley. So just come stand up at that podium, Mr. Lamley. All right, I have Rhonda Underwood appearing on behalf of Mr. Lamley, and I have Joanne Holly appearing from the probation department. This is a date and time set for a pretrial on the violation of probation. So, Ms. Underwood, how do you wish to proceed?
Thank you, Your Honor. I would ask the court to enter a not guilty plea on Mr. Lamley's behalf, Your Honor. It's my understanding he did report to Ms. Holly yesterday, and I believe he does have some reasons why this has taken so long, but he's back reporting, and I would ask, I guess, for a 2-3 week adjournment for a pretrial in this matter.
Ms. Holly, he reported.
Yes, he's reporting again. If he shows me that documentation he said he has, I have no problem with just monitoring it and continue on.
Do you want to dismiss this violation then?
Yeah, that's fine. If something happens and we need to do it again, we'll just bring it back.
All right, so Mr. Lamley, I'm going to dismiss this violation of probation, but if you stop reporting, we're going to do a violation again, all right? Okay, very good. Thank you, Mr. Lamley. All right, Mr. Barnett, if you want to go out to the hallway and go stand in front of the Zoom device, Miss Underwood, can you join your breakout room again?
Thank you, Your Honor.
Yep.
Try to do that.
And that is file number 2025-22302FH. It should be down on that bottom bar. There she is. Miss Messer, do you have another one this morning?
Yes, Your Honor, I have Mr. Klein.
Okay, I'm sorry, I missed that.
No,
all right.
No worries, thank you.
All right, Mr. Dagger Margosian. All right, this is file number 2026-22563FH in the matter of the people of the state of Michigan versus Marcos Martin Ramirez. I have Michael Dagger Margosian appearing on behalf of Mr. Ramirez, and I have Isaac Sneed appearing on behalf of the people. I do see a demand for a preliminary exam transcript that we already received it. I have, so we've got that. Mr. Dagger Margosian, how do you wish to proceed today?
Your Honor, may I speak with Mr. Ramirez, please?
Of course, Mr. Ramirez, I am going to send you an invitation to join a breakout room.
Okay,
And
ma'am.
speak with your attorney. So when you get that, your Zoom 5, when you get that, go ahead and join that breakout room.
Okay.
All right, so. Come back, if you want to just come up to the podium for me. Okay, so we are on the record in file number 25-22302 FH in the matter of the people of the state of Michigan versus Kevin Lee Barnett. Ms. Underwood, I did screen Mr. Barnett, but is Mr. Barnett eligible for court appointed counsel?
He is, Your Honor.
All right, and Ms. Underwood, how would you like to proceed with Mr. Barnett today?
We would ask the court to enter a not guilty plea on Mr. Barnett's behalf. Mr. Barnett believes there should be an update from John Bailey on this issue, Your Honor, but if not, we need some time to track that down. So we would ask for perhaps the August 5th date, Your Honor.
Okay, I don't have that available anymore. I'm at August 19. Ms. Holly, for expediency's sake, have you received an update from Mr. Bailey?
Yes, he is back in attending treatment, so we can push it off for a while to monitor.
All right, how about September 16?
That's fine.
At 8:30 in the morning. Miss Adams, could I get a notice from Mr. Barnett for September 16 at 8:30 in the morning?
Yes, Judge.
All right, so Mr. Barnett, I'm glad you're putting in your phone. Honor a plea of not guilty. Have a seat on the bench behind you. Are you employed?
I am.
Okay, we're gonna give you a Zoom notice too.
Okay.
And then have a seat behind you on the bench and my assistant will get you a notice of hearing, all right?
Thank you, Anna.
And finish the programming.
Yes, ma'am.
Okay. All right. So, let's go with Mr. Klein, or
Your
no,
Honor, I'm
hold
sorry,
on,
what is that date again?
September 16. All right, Ms. Underwood, do you need a breakout room with Mr. Klein?
Yes.
All right, let me call it, and then Mr. Degermont goes in, I'll skip to you. All right, this is file number 22-20712 FH, 23-21223 FH, 23-21225 FH, in the matter of the people of the state of Michigan versus Jake Gordon Klein. I have Rhonda Underwood appearing on behalf of Mr. Klein, and then I have Ashley Messer appearing on file number 22-20712 FH, arrest in a violation of probation. So I'm going to open up a breakout room. Hold on, let me delete all these other breakout rooms. All right, and Mr. Klein, you're going to get an invitation. Where are you, Jim? Zoom? To join a breakout room with Miss Underwood. Join that breakout room. All right, we are back with Mr. Ramirez. So this is file number 26-22563FH in the matter of the people of the state of Michigan versus Marcos Martin Ramirez. Mr. Dagger-Margosian, how do you wish to proceed today?
Your Honor, good morning. Michael Dagger-Margosian for Mr. Ramirez. Your Honor, Ms. McClure is the assigned APA on this matter. I have been speaking with her. We're still coordinating, trying to resolve this. She needs about a week or two to talk with pertinent people involved here. So we'd be asking for an adjournment to the next pretrial date, please.
So I can't do that because my next one, I have over 20. My next available is August 12. But Mr. Dagger-Margosian, if you are able to reach an agreement with a prosecutor, I can bring Mr. Ramirez in on a day that's not a Wednesday to take a plea. So I am going to set it over to August 12 for pretrial at 8:30 in the morning. And Mr. Dagger-Margosian, if you can do the stipend order to adjourn. Mr. Sneak, can you sign your name with permission?
Yes, and if I could address the court before we end the matter.
Yes.
Received a report from the victim that the defendant has been contacting her family members. So we'd just like to add or modified pretrial conditions to include no contact with the victim and her family members.
Okay. So, Mr. Ramirez, understand no contact also means no contact with, in this case, I'm gonna amend the bond condition to her family members. But, you know, third party contact to the victim also is a violation of bond conditions. So, I will amend the bond conditions for that purpose. Mr. Degemer goes in. Just remember, Mr. Ramirez,
Yes, ma'am.
that, you know,
Yeah.
that could result in contempt of court.
Yes, man. I wasn't trying to get a hold of her.
Hey,
No,
stop,
no, no,
stop
don't
talking.
say anything, don't say anything, because, you know, you, that could be used against you. So, all right, we'll see you back on that day, if not sooner. And Mr. Degemer goes in, you can prepare the step in order. You're all set, Mr. Ramirez. Thank you.
Thank you, ma'am. Thank you, Michael.
Okay, so Rhonda Underwood, we are back with Jake Klein. Oh, let me find this stuff. Okay, and let me call the files. 22-20712 FH, 23-21223 FH, 23-21225 FH. So, Ms. Underwood, how do you wish to proceed with Mr. Klein?
Your Honor, Mr. Klein has a probable cause with Ms. Malaturno on the 27th of this month, Your Honor. So I believe it would be appropriate to adjourn these matters till after that. And I just want to make sure, Your Honor, that there is a nominal bond on these matters so that Mr. Klein is getting credit.
Yeah, they're violation of probation, so I'm pretty sure. Let me double check. Usually I set it at, yeah, he's got like $50,000 bond on one. Yeah, he's got bond. Okay. All right, so I'm gonna set this over to August 12 at 8:30 in the morning. Miss Adams will do the notice of hearing because it's a probation violation. And Miss Messer, I'll see you or someone else that day.
That works. Thank you so much, Your Honor.
Thank you. Yeah.
Thank you. You're all set, Mr. Klein. Thank you. All right, and I feel like I didn't call enough files. Did we call all of them? No, I only have 3 files, but there are 4 listed on the docket. So on the docket was 22-20712 FH, 23-21223 FH, 23-21225 FH, and 25-22402 FH. So all of those will be set over to August 12 at 8:30.
Who is that judge, the name? Is that
Huh?
Klein? Is that Mr. Klein?
Yeah. I only had 3 files on me, so I wasn't calling all the ones that were on the docket. All right, so now I have Mr. Signs. And Miss Underwood, the paperwork I received from the public defender's office said you were appearing on Signs today, but
Okay. I can do that, Your Honor.
let me call the file. So this is file number 2024-22047FH in the matter of the people of the state of Michigan versus David Royal Signs. So Ms. Underwood, this is the violation of probation file. You were appointed on that. I believe he has a new file and she might be on that one.
Thank you, Your Honor.
On this file, I have a June 23rd of 26 violation of probation, which alleges that on March 19 of 26, he was found in possession of methamphetamine by APD and pled guilty to felony possession of methamphetamine on June 17 of 26, which is set for sentencing on July 30th. So that must be where Ms. Zoki pled him. And then there's contempt of court for failure to appear for a probation violation on March 18 of 26. Then then there was contempt, no, same one. Then there was a violation of probation from March 2nd of 26, where the allegations that he committed the technical violation, failed to report since his release from jail on February 8 of 26. And then a non-technical probation violation that he violated his probation by committing the offense of retail fraud second degree in the city of Adrian, I'm sorry. And then on another one for January 10 of 26, it's alleged he committed another retail fraud third degree in the township of Madison. So those are two technical, non-technical, one technical, plus the contempt of court for failure to appear for a probation violation, and then the new one for possession of methamphetamine. So has he pled to any of those, Miss Holly? I don't think so.
He pled to the new one, but I was just gonna look up the retail frauds. I think he did, but I'm gonna look it up right now.
I did, Your Honor.
You did?
What happened on those retail frauds? Did you get sentenced?
I got sentenced to 93 days, Your Honor, and I've done that already. So I'm sentenced to that, and that file's already cleared out. I'm done on that.
Yes, yes. Yes. So yeah, we
Okay.
can clear these up so sentencing can all be the same day, is what I was thinking.
So Miss Underwood, do you want a breakout room with Mr. Sines?
Okay, just so I understand.
No, he's on possession for a possession of, he's on probation for possession of methamphetamine,
Correct.
which means the maximum penalty could be up to 10 years in prison. So I'm going to give you a breakout room with Mr. Sines. If he wants to plead to the violation of probation, I could set him over for a sentencing date on the other one. All right.
Well, I want to know which violations he would be pleading to, and
So he'd be pleading to failure to report. He's charged with 2 retail frauds, one in Adrian, one in Madison Township. It sounds like he pled to them and got jail time on those, so he'd have to plead to those, as well as pleading guilty to the next violation would be pleading guilty to the felony possession of methamphetamine.
Rhonda, I
So
can
two-
dismiss, the one on January 10 was dismissed, so I can dismiss that count. But he did plead to the other, the 12/26 one.
Okay, so she'll dismiss the Madison Township retail fraud violation. So it would just be, he would have to plead to the retail fraud for the city of Adrian that he got sentenced on, failure to report since release from jail on February 8, and then pleading guilty to possession of meth on June 17 of 26.
and that's the sentencing that is on the 30th.
Yes.
Yes, Your Honor.
Okay, and everything else would be dismissed.
Yes.
Okay, now I'll take my breakout room.
All right. Do you understand all that, Mr. Sines?
Yes, Your Honor.
All right, I'm gonna put, join the breakout room, talk to Miss Underwood. I just admitted somebody on a Samsung device. Can you unmute your device and let me know who you are?
Is it still muted?
Nope, I can hear you. What's your name?
Zachary Rosenberg, Your Honor.
All right, that beard throws me off. All right, I'm gonna rename you. And then Mr. Goldstein should be zooming in pretty quick, all right?
Okay, Your Honor.
All right, and I'm gonna pop you in the waiting room. And then, yeah. All right, thank you.
Yeah, I think that's it for the docket as far as our office goes, right?
I think so. I actually, yeah, I have a Donald Raymer at 11, but that's a district court
Nick is
case.
coming up for that one.
Okay.
What happened
All right,
to Tony
thank you.
Rowe? What happened to Tony Rowe?
I think adjourned to August 5th with his new case.
Okay.
Okay. All right.
Have a good one.
Okay, I'm gonna bring Mr. Is he gonna plead, Brenda?
Yes. Do you know if he's been screened for recovery court yet?
I don't know. That was talked about, but I don't know.
I think Mr. Sines has been in the past, but
Your Honor, I was screened for your recovery court probably a few weeks ago and I was approved like a month ago.
okay, okay. So Miss Underwood, give me just a second. Is Mr. Sines gonna plead today?
Yeah.
Yes.
Okay, so hold on a second, Mr. Sines. Mr. Goldstein, are you there? I'm gonna skip over to David real quick, Miss
Yes, Your
Underwood,
Honor.
just, all right, this is file number 24-22047FH. In the matter of the people of the state of Michigan versus Zachary David Rosenberg. I have David Goldstein appearing on behalf of Mr. Rosenberg. This is a violation of probation pretrial. The jury trial that was supposed to begin today, those charges were nully crossed. Let me see here. Get back to that violation. Is that long ago? Is this the July 16 of 25 violation of probation?
Yes.
Yes, Your Honor.
Okay, all right, so,
It is a
Mr.
different matter. It happened before the drug case. It has nothing to do with the new thing, so it's still, we could go on with this.
So, Mr. Goldstein, this one involves assaultive behavior. The charges that were dismissed today were, drug charges. No, yeah,
Well, the felony was a drug case, Your Honor. There was also a misdemeanor case that's being dismissed, that's due tomorrow in front of Judge Morgan, that had to do with breaking in with entry without permission
Right,
on the same victim.
right. But this domestic happened a couple days before all of that, and he actually did plead guilty to domestic violence on November 3rd, 25. He's on probation in district court for it. So it's
Yeah.
completely different. It happened
Yeah,
a couple days
I
before all of
understand.
that.
I understand.
Okay.
so Mr. Goldstein, how do you want to proceed?
Well, Your Honor, we want a hearing. I mean, my client's been up, my client, since he pled guilty, well, since he committed the offense in district court of July of, I think he pled in July of last year. It's been it's been a year and he's had no problems. So, I mean, if we want to go ahead with it, that's fine, but we want a hearing.
Okay, Miss Adams, could I get like, Mr. Goldstein, do you know, I know your schedule's pretty busy, but do you have any days you're gonna be around, Adrian?
Let me take a look, Judge.
We can try to accommodate that.
What? Oh, no, yeah, I just said something in front of Judge Olsaver. I think it's on the 5th of August.
Is that a jury trial or?
No, it's a pretrial.
Yeah, but I mean, do you want to do this in person, this VOP trial, or via Zoom?
No, I can do it on Zoom, Your Honor.
Okay, Mr. Rosenberg, do you have any objection to doing a violation of probation trial on Zoom?
No, I don't have a problem, Your Honor. I just wanted to state for the matter. I mean, I've already served time for that too.
In district
All right.
court.
Yeah. So, all right, Miss Adams, I'm looking for like an hour somewhere.
Judge,
via
August
Zoom.
5th. Yep, August 5th, we have Mr. Goldstein on a motion at 10:30 if we want to do it 11 o'clock.
That's fine.
All right. So we will do the VOP trial August 5 at 11 a.m. We will do the notice of hearing. We will send the copy out to the prosecutor's office as well as to you, Mr. Goldstein. And Mr. Rosenberg, you can just zoom in that day for that. All right?
Okay.
All right. Thank you. Anything
Thank
else,
you.
Mr. Goldstein?
No, Your Honor.
Okay, perfect. All right, back on the record in file number 24-22047FH. Miss Underwood, how does Mr. Sines want to proceed on the violation of probation?
Your Honor, he will plead guilty on the violations.
Okay, let me get back there. All right, so Mr. Sines, raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, so Mr. Sines, did you receive a copy over time? You can put your hand down. Have you received copies over time of your violation of probations and failure to appear notices? Do you understand the charges against you?
Yes, Your Honor.
All right, and you understand you're on probation for for possession of methamphetamine, and that does carry a maximum penalty of up to 10 years in prison if you plead guilty or found guilty potentially. Do you understand that?
Yes, Your Honor.
Are you satisfied with Miss Underwood as your attorney and the advice that she has given you?
Yes, Your Honor.
All right, do you understand that you have a right to contest this violation of probation charge and to have a trial on it? Do you understand that?
Yes, Your Honor.
Do you understand that throughout the trial, you would be presumed innocent till your guilt is proven by a preponderance of the evidence? Do you understand that?
Yes, Your Honor.
You have a right to have all of the witnesses against you appear at your trial, to have your lawyer ask those witnesses questions, or you may ask them yourself, and to have me order any witnesses you might have to appear at that trial. Do you understand all of that?
Yes, Your Honor.
You do not have to testify at your trial. No one can say anything about you not testifying or hold it against you in any way. Do you understand all of that?
Yes, Your Honor.
On the other hand, do you understand that you have a right to testify at your trial if you want to testify?
Yes, Your Honor.
All right, so Mr. Sines, we're going to look at the violation of probation that was filed on June 23rd of 2026. How do you plead to the charge that you violated your terms of probation by pleading guilty to felony possession of methamphetamine on June 17 of 2026 in this court? Guilty or not guilty?
Guilty, Your Honor.
All right, and how do you plead to the violation of probation charge that was filed with this court on March 2nd of 2026, that you failed to report to probation since your release from jail back then on February 8th of 26? Guilty or not guilty?
Guilty, Your Honor.
And then on that, the non-technical violation, how do you plead to the charge that you violated the terms of your probation by pleading or by committing retail fraud second degree on December 26th of 25 in the city of Adrian, and then you pled and were sentenced on that one? Guilty or not guilty?
Guilty, Your Honor.
You understand by pleading guilty to these that you'll be giving up your right to a trial and that I've already explained to you.
Yes, Your Honor.
All right, and then how do you plead to the charge of the contempt of court that you failed to appear for a probation violation hearing on March 18 of 26? Guilty or not guilty?
Guilty, Your Honor.
All right, has anyone promised you anything to get you to plead guilty?
No, Your Honor.
Has anyone threatened you in any way to get you to plead guilty?
No, Your Honor.
If I accept this plea, you will be giving up any and all claims that your plea, I apologize, I've been talking nonstop this morning, that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea. Do you understand that?
Yes, I do, Your Honor.
And it's your own choice to plead guilty.
Yes, Your Honor.
All right, so we're going to go all the way back on, let's see. So you were placed on probation, and one of the terms of your probation is that when you got released from the jail, you were to report to the probation department on February 8th of 2026. Is that correct?
Yes, Your Honor.
Did you fail to report to the probation department when you
Yes,
got
Your
released
Honor.
from the jail?
Yes, Your
Okay.
Honor.
Now, on December 26th of 2025, did you get charged with retail fraud, second degree in the city of Adrian?
Yes, Your Honor.
And you actually ended up pleading to something on that charge?
Yes, Your Honor.
Okay. So then we mailed to the address, or the probation office mailed to the address we had on record for you, but although you were homeless at that time, that a probation violation hearing was scheduled on March 18 of 26, and you failed to appear for that hearing date. Is that correct?
Yes, Your Honor.
All right. And then on June 23rd of 2026, another probation violation was filed, and that alleges that you pled guilty to felony possession of methamphetamine on June 17 of 26 in this court. Is that correct?
Yes, Your Honor.
In fact, you are set for sentencing on July 30th of 26 at 8:15. Is that correct?
Yes, Your Honor.
All right. I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. I'm going to refer this matter to the probation department for a probation violation report, and I will set it over to July 30 at 8:15 for sentencing. Are you appearing via Zoom for the other sentencing, Mr. Assigns?
Yes, I am.
Do you want to appear via Zoom for this one?
Yes. Yes, Your Honor.
All right.
So I have two sentences on the 30th then?
Yep, they'll be at the same time, and Miss Underwood will probably sweet talk Miss Zilke to doing the probation violation. Miss Zilke into doing the probation violation sentencing as well, so Miss Underwood doesn't have to come, all right?
All right, and I should be seeing Miss Moliterno for the other one, right? Or is Miss Zilke
Is
gonna
that
take?
the misdemeanor?
No, that's the felony meth possession. And I'm gonna see Miss Zilke. for
Oh,
both.
so that's Miss Moliterno, yep. So she'll probably get sweet talked into doing that one as well for the probation
Okay.
violation. So, all right, we'll see you back on that day, Mr. Sines. Thank you.
All right, thank you. Thank you, Your Honor.
All right, Miss Underwood, thank you. So, Miss Underwood, is there anything else you have with me this morning?
I don't think so.
All right, well, all right, I have one last thing, which is the district.
I will be back this afternoon, but I don't think it's with you.
Yeah. I have a Snyder versus Miller at 2:30 with you.
Yep. Thank you, Your Honor.
I think I'm
Thank
done
you.
as well.
Okay, yep, this is a misdemeanor. All right, are you on Raymer?
Miss Swift did show up.
Oh, are you Miss Swift? Yes. Oh, okay. So, you're gonna have me set up for another date?
We can keep the, just because Mr. Bayonetto's not here, if we could just keep the.
Get Mr. Bayonetto on the phone.
I mean, we can keep the same date. It's just
Okay.
as far as the.
Okay, so this is file number 2025-22497FH in the matter of the people of the state of Michigan versus Carrie Ann Swift. Called it earlier in our roll. She is now present. I have Dylan Marquette present as well. I am going to set aside the bench warrant. This is set for trial. Are we keeping the trial?
If we could keep the pretrial date on.
You don't want the trial date?
9th.
Okay.
Just what we talked about.
All right, so Miss Adams, I'm going to keep the pretrial date on, I'm gonna take the trial off and set it for pretrial July 29 at 8:30 in the morning. Could I get a notice of hearing for Miss Swift, please, for July 29 at 8:30? So, Miss Swift, you know, you are potentially facing up to 2 years in prison on this. You may not think it's important enough to show up in my court when you're required to, or stay in, I'm not asking you to talk. But my court schedule is pretty tight, so it's not at your leisure. So if you have an 8:30 hearing, you be here at 8:30 in the morning. and you stay in contact with Mr. Raquette, because I can do one of two things. Put you in jail where he can find you, or put you in jail where I can find you. Do you understand? Say it louder.
Speak up, please. I need
All
you
right.
by the mic.
Absolutely. All right, so have a seat over here at the end of this bench. We will get you that notice of hearing. Mr. Raquette, you have his contact information. If you're going to trial, you better prepare with him, okay? Say it louder. Absolutely. All right, have a seat right over there. We'll get you that notice.
Quash the bench warrant, Judge?
What?
Quash the bench warrant?
I did, yeah. Okay, do you have Mr. Raymer? I did. All right, this is, do we need, Becky or Miss McGrain, did district court want somebody up here or no? I don't know. Okay, so this, can you both come stand at the podium? All right, this is file number 25-2289OM. This is in the matter of Adrian City versus Donald F. Raymer. I have Diane Malaterno appearing on behalf of Mr. Raymer. And is this a bench trial?
It's just a contempt hearing is my understanding.
Okay.
It's really out there. I don't know what's going on.
Okay, so, let me look back here. So we have motion affidavit in order to show cause. It's a violation of probation must appear on March 12 of 26 at 8:45 to explain why you should not be held in contempt for your behavior with staff at the counter on Monday, February 23rd of 2026. So that is the contempt of court, and then for whatever reason, it's now up here in front of me. And today is the time set for hearing. And you know what? That's why, because it's not quite 11 o'clock yet. And this was set at 11.
Yeah, I was notified that Becky called and said we could start early, so I
We
said I
can,
could do it early.
but let me go. And Mr. Raquette, are you staying on this? Okay, I'm just checking. So I'm gonna take a recess. Go ahead and have a seat, and then we'll let the prosecutor's office know that someone is, well, never mind. Here's my prosecutor. All right. So, we will not take a recess. Do you need a recess, Miss Faye?
No, I'm fine.
You sure?
Yep, thank you.
All right, so evidently this is date and time set for, like, it's all gone, okay. This is the date and time set for hearing on a contempt of court. I have Nicholas Sears appearing on behalf of the people, and as I said, Diane Malaterno appearing on behalf of Mr. Raymer. Are we ready to proceed? Miss-
Let me go get a hold of Miss Ducat, the witness or the witnesses for this.
Miss Ducat?
I have one on the way also.
Krista.
Who?
Yeah, Krista Ducat, Heidi Cannon, and
I can let Miss Cannon know. I don't know those people, so.
Krista's extension is 4650.
I don't know district court people. So.
4650.
Yeah, 4560 is your number.
Judge, I just texted Ms. Cannon.
Heidi Cannon. What'd you say, Miss McGrain?
I just texted Ms. Cannon that you were starting a bit early, so they should be up.
Here we go. So, So, we now have, a couple people present, and who's your witness, Ms. Moliterno?
Shane Raymer, the defendant's brother.
I'm sorry?
Shane Raymer, the defendant's brother.
Okay, and he's
en route.
Okay, do we expect him in the next couple minutes?
Yes, within 10 or so, but I think that we can start because if it's.
That's what I'm wondering. I mean, if
I
he's.
believe that's fine.
All right, so, all right, so we do have two people from district court. So, who are you gonna, call first?
I'll be calling Ms. Duquette first.
Okay, no, not yet. So I'm gonna have you sequester. So what I'm gonna have both of you do is go have a seat at the end of the hall. And then, when we're ready to bring you back in, someone will come get you, okay? All right, so, do you have an opening statement, Mr. Sears?
No, at this time, we would waive it.
Yes, Your Honor.
Okay.
Can waive it. First of all, I do need to make the court aware of one flaw, I do believe, in the filings. The last time we were here, the motion to show cause was supposed to be supported by an affidavit. We did get an affidavit, but it's talking about two completely separate incidents. The affidavit isn't discussing the subject of the show cause. So I still don't really have the allegations, the sworn allegations from someone who was there and witnessed
I
it.
thought there was a report that was done that was supposed to be provided to you.
It wasn't based on this incident.
This is the only report that I have, and it was provided to us after that hearing, Your Honor.
Is it regarding that incident? Can I talk with you two and back?
Yeah.
This way, please.
We have to go back and
Yes.
this court likes us better.
Where do you get that?
Please rise, your court is now in session.
All right, will you bring the witnesses in? Please. Okay, so we are back on the record in file number 2025-2289OM in the matter of the people of the state of Michigan versus Donald Raymer. This is a date and time that was scheduled for an evidentiary hearing on the allegations against Mr. Raymer. The last time we were here, I did strongly advise Mr. Raymer that we have a zero tolerance policy, obviously, for misbehavior in the courthouse towards staff, and that I don't tolerate it with my staff. But the motion affidavit and order to show cause was not pled in specificity, or nor was it notarized at that time. And the last time we were here, I did request a police report so that the parties could defend and be prepared to defend, and we have not received that. There's some kind of statement, but it doesn't have anything to do with this. So I'm not able to proceed at this point. I am going to dismiss this contempt of court. But Mr. Raymer, you know, we're not in the UK, we're not in a country that using the C word or talking about people's looks or anything else in a professional setting are appropriate. If I were to say something to Miss Moliterno, although she looks nice, and Mr. Sears, well, he looks nice, but he looks 12 years younger because he shaved his mustache off. If I were to mock what their clothing is or mock their face or anything like that, I would be held responsible to the JTC. Do you understand that?
Speak up, sir.
Speak
I
up.
need you to speak
Yes,
up.
ma'am.
This is a professional establishment. We expect you to behave that way. We know that the people that come through here are stressed, are upset, under duress, whatever it might be, but so are the staff. And so you don't have a right to treat people that way, whether you did or not, I don't know, because you haven't been found guilty of it. But understand that you cannot treat people like that in a professional setting. All right?
We did discuss that at length too, Your Honor.
All right, very good. Thank you.
Thank you.
Thank you.
That concludes our docket.